Ladies and gentlemen, I'm sorry for any inconvenience. The room is apparently too small. I do not expect so many people. I just come from the courtroom, which was presided over by Madam Justice, Her Honor Judge Lowe, and she traversed the matter to the divisional court. There's a variety of reasons for that, not the least of which is the availability of a judge to hear this on an emergency basis. So it's gone over to the divisional court to be heard by a single judge on the 30th of May. I know there's a 2-month delay. She was powerless to grant any kind of interim relief at the moment. However, on the other hand, I was given assurances, if I call it, by the Council for the Transitional College of Traditional Chinese Medicine and by the minister that the Transitional College is much too busy trying to register people or trying to do something than to occupy themselves with any kind of sense of prosecution about anybody who is going to continue. So my best advice is that people can continue what they do, even though the regulation is going to be passed on the 1st of April. The people go ahead and continue the treatment. Patients go ahead and be treated by your doctor, and the matter will be resolved very clearly on the 30th of May. Since this is a constitutional issue, it is not likely that anybody will want to prosecute, because if they do, it creates the same constitutional argument under Section 7. And so that people should go about their business and not worry about the 1st of April. That's my advice. Anybody who doesn't like that advice or is concerned about it can contact my office, and we'll be happy to respond. And there are people who speak Chinese only. We have a Chinese-speaking person at my office who can answer. I'm sure Dr. Lee and the people sitting at the table who have been very responsible and very diligent in trying to bring to everybody, to the attention of the minister, to the attention of the premier, and to the attention of the college, that this matter is unfair, because particularly because of the language problem, particularly because of the fact that this bylaw was conceived, in fact, only in December and passed only on the 25th of January. And as I understand it, registrations were to have been stopped on the 19th of March, although I'm told now that there is some kind of extension and people are trying to rush through to try to pass some kind of examination. I'm not sure which, and I'm not sure how. The fact is that this thing has been lying fallow since 2006, when the idea of regulation was first conceived by the passage of a Traditional Chinese Medicine Act by the province of Ontario. What has happened between 2006 and now, which merited a rush to register in less than 8 weeks, I don't know. That has not been explained. We'll find out in cross-examinations when we come to it, because I'm sure there's going to be affidavits in which I can cross-examine. But what particularly confounds me, and I'm just a third-party observer, although I have an interest in Chinese medicine, what confounds me is that the British Columbia College recognizes the bilingual nature of the practice, that this is a practice that was conceived in China, it's culturally Chinese, brought to Canada by Chinese, and practiced by Chinese primarily, in a tradition, in a precedent, in a form that is unlike Western medicine. It's something completely different, based on different ideas and based on different concepts. So the British Columbia College recognized this fact. Their education is in Chinese. Their exams are in Mandarin orally, and of course written is in Chinese, because Chinese, Mandarin, or Cantonese the same. They recognized this. And when the backgrounder was written by the minister's representatives who made recommendations to the Minister of Health and Long-Term Care about the passage of regulation, they said that the precedent established in BC should have been observed. Now, I don't know why it wasn't. And, of course, this language element is a key issue, and there are others that I'm sure Dr. Lee has described. But that's a very short statement of it, and if there are any questions, I'm still needing some coffee or some water because I just rushed from the court. So, anybody wants to ask me anything?
Can you just explain what you will defend in court about the language there?
Well, I think that the language barrier offends Section 15 of the Charter, and it offends Section 7 of the Charter. It's manifestly unfair, and it's discriminatory. And those are going to be my arguments.
But why is it discriminatory is it just against the Chinese community? Why do you think the government goes this way?
I don't know. You'll have to ask the minister, and you'll have to ask Mr. Chung why it's important to extinguish the Chinese language when dealing with precedent or discipline that's entirely Chinese. I mean, it confounds me. That's what is discriminatory. It separates people, different kinds of people, for different reasons.
What I'm trying to understand is what's the difference between the level of language you need in order to come to Canada and the level of language you need in order to pass those two exams?
Well, the language that is required is supposed to be written, spoken, and reading in a reasonable English. Now, I don't know what reasonable English is, and right now, English is a precedent for coming to Canada, but it hasn't been. And so all these people came to Canada without the need to speak English. It was one of the criteria they looked at, but they could come here without it, and did so. And the language of the discipline is in Chinese. I can't tell you anything else, but it certainly discriminates between different classes of people on the basis of race, i.e. Chinese. I can tell you that this discrimination against Chinese has been going on for a long time in various ways, and I thought we were out of it, but apparently we're not.
And what do you think of the arguments that English and French are the only official languages in Canada, and Canadians, who cannot understand Chinese, would be excluded from the benefits of TCM?
Well, apparently both BC and this college have methodologies of translating some of the principles into the English language. You'll see, if you look at the regulations, that there's glossaries which do exactly that in the form of acupuncture and herbal remedies. In fact, the peculiar part is that the glossary with respect to herbs is written in the Chinese language. So there's already a Chinese language as part of the glossary of the regulation which prohibits speaking English, prohibits speaking other than English. I hope that helps.
And why is it taking so long? Because obviously there have been a lot of concerns and tensions between, your group and the transitional college. Why it is taking so long? And also the law was introduced in 2006. Why is it taking so long to bring forward the illegal action?
I don't know, because, I just came upon this. I've not been the Federation's lawyer for until recently, at the beginning of March. But I've done a lot of reading on the Internet, and I recognize that there's a thing called the CMAAC, which is a federal organization organized by this Cedric Jung, and it's in big trouble with the province of Saskatchewan people, because I've just been reading about that, and there's a lot of tension in groups involved in this thing. But as far as the Ontario group is concerned, I know that they had 2 public meetings at which the Chinese were particularly biased or excluded, and that's in the reference to the affidavit of Dr. Jia, which can be distributed. You'll see the particulars of that. So, actually, the college, since 2006, of transitional medicine, it's funny, it's transitional, traditional, is really basically a do-nothing group, in my view, from what I can see. Do I have agreement on that, Dr. Lee? Basically, a do-nothing group?
They didn't listen. They don't want to listen to the professional ideas and from the public. They just do whatever they want to think to do on it.
All right, thank you.
Sir, I just want to double confirm that you propose that the practitioners can continue their practice after April 1 until May 30.
I don't propose it, but I suggest that the college is too busy doing other things, and I was told that by the two lawyers who represented the two parties this morning.
What's the range of fines or penalties if...
$25,000 for the first and $50,000 for the second, plus 2 years in jail. Possible. Up to.
So what's going to happen after May 30 and during the trial, before any ruling from the court?
Well, the court is going to make a ruling of some kind on the 30th of May. It may be an interim injunction until the matter is fully heard. If there's enough material before him, he may make a final order right there and then. Don't know. We're going to see, because as you can see, I don't know if you can see it or not, we have a huge booklet of exhibits about this thick, plus an affidavit of Dr. Lee, plus an affidavit of Mosen Seta. Now they're going to be examined on, and we're going to get affidavits saying that what we say is probably not right or whatever. So that interplay has to happen, and I'm satisfied by the cooperation that I got from the counsel for the Attorney General and the counsel for the traditional, that they would cooperate and bring this matter on. I think they want to have it decided too. I also suspect that the minister, together with the Premier of Ontario, may want to have a second look at this whole thing. I hope they do. I mean, the Federation represents an umbrella of 8 groups, actually. So there's an extraordinary unanimity amongst the groups of Chinese that are affected. And they want to practice their trade, their profession, in their language, although I agree they have to have an ability to explain their treatments to Occidentals and to Western doctors if they needs be. But I don't think they need a huge focus of highly intellectual language to do that. And I know from speaking to members of the Federation that a lot of them speak English with a very highly accented nature. So you have to listen twice to what they're saying, but that doesn't mean that they don't speak English reasonably. Now, the funny thing is that, as an immigration lawyer, I've been involved with this whole issue of trying to obtain a definition of what is speaking English well or whatever. It's been now we have testing for that. There's an IELTS test which demonstrates it very adequately. And so I would say that probably the Federation people should speak English at least up to an IELTS of 3 or 3.5. That would be reasonable. But whether that's reasonable English in the view of those who are examining from the Federation, from the traditional, I don't know. I mean, who wants to be examined by somebody who you had a fight with as to whether or not you speak English reasonably? And that's just not reasonable.
So in your opinion, do you think the petitioners wait until the 30th of May, including the registering with the Association Council?
Well, if they can register before, why not? If they can. Why should they wait? But if they can. But the problem is that there's other problems with the regulation. For example, a simple example is a practitioner who has an ability to prescribe herbs is forbidden from charging for it. He can only charge for the exact cost of the herbs. This interferes with his practice. A doctor who sees a client, traditional doctor who sees a client who has been recommended surgery, cannot touch that client, even though the client doesn't want surgery. I mean, there are a whole variety of small little things built into the even the traditional doctor who has a client, let's say, who has who sees a client who's already having a a heart attack. Well, he calls 911, but he can't do anything in the meantime to try to relieve against the stress of that person, even CPR. So this is kind of nonsense built into the statute. A whole variety of them, and I just refer to the herbal and the language as just two of them.
Excuse me.
How am I doing, Minnie? All right?
Good. The group that you represent actually established a self-regulated body, and they say that over about 900 practitioners have registered already. Is that like what do you think of this body? Is this something that practitioners should register with? Is this something that's legal?
Well, the problem is you can register, but your practice is restricted in a way that and when you say 900 people have registered, I'm not sure there are 900 Asians who have registered. Okay, so I can't really answer your question. All I know is that the group that I represent stands for a college that represents the highest quality of treatment that can be given, and it should be regulated, self-regulated, but in a fair and reasonable way.
If the province was to copy the way British Columbia is doing it, would you be okay? Would your client be okay with it?
Well, 90% okay. I'm sure I have to take a look at the full regulation, but the language would be a big issue to overcome. I mean, that was what was recommended to the province.
Because you say beside the language there might be other barriers. That's what I'm trying to understand.
Well, that's one is that herbal barrier. Certain other barriers restricted. I think once we got over the language issue and we had a college that we could talk to and would listen to us, I'm sure we could overcome the others.
May I just add one more thing to our lawyer? The language thing is not only the daily language for English, talking about hello and how do you feel, whether you have a headache or whether you feel comfortable today. The Chinese medicine is a very different.
Would you mind going closer to the microphone?
Traditional Chinese medicine actually practiced very differently. It's very different than biomedical medicine. So the terminology is in Chinese, not only the Chinese language, but it's a very different term. For example, if someone comes in and says, I have a headache, I need to do examination and come up with a diagnosis. In Chinese medicine diagnosis, that we'll call liver fire arising. So to a lot of non-Chinese public or the medical doctors, whether I'm saying in English or Chinese, in English words, they didn't understand very well. So they have to understand the traditional Chinese medical terminology. If someone comes and say, I couldn't sleep well, it's insomnia, but what kind of insomnia? Based on my examination, they will say, okay, that insomnia is caused by heart and kidney in disharmony. That's in Chinese term, in English words. So that it's not just saying, we need to speak some reasonable English to understand each other, but the tradition, probably like, the tradition in French as well, and there's a heritage of that. It's a very important, unique part of the Chinese medicine. So to say you cannot use that, have to use exclusively English, it's not going to be practical, and it's got to be manifestly unfair.
Credentials of people with respect to acupuncture that are less than qualified, in our view. For example, the qualified practitioner in acupuncture will have at least 3 or 4 years of university training. But I saw a website of one Rapson where you could become a qualified acupuncturist with 100 hours of training, education, and only 23 of those classroom, the rest of them on distance learning. So there's a problem with credentials and establishing who is who. Now, we have challenged the credentials of Cedric Chung and the credentials of Ms. Pritchard, and we say we can't find evidence that these are real credentials. In other words, the affidavit of Lee, Dr. Lee, states that there's reason to believe that these credentials are not true. And so we now have a college, a majority of which is establishing the credentials for practicing acupuncture and traditional Chinese medicine, whose credentials themselves are not exactly worthwhile looking at until they prove them. And we have suggested that there's a organization called World Educational Service where you can get those credentials authorized exactly. But the credentials we've seen are not exactly authorized credentials. So here we have a college who's brought into force a regulation which says we're going to establish all the necessary credentials to establish experience, and who is experienced, who is the highest experience, and who is just medium experience, and who is a qualified acupuncturist, when in fact their credentials themselves are not exactly accurate. So that's another problem. I mean, there's a variety of problems built into this thing. The affidavit of Dr. Lee is how many paragraphs? Your affidavit?
165.
165 paragraphs. So it's not a small topic. So that has to be examined thoroughly in order to get the flavor of this. There's also an affidavit of Mohsen Sada who testifies about the BC experience being bilingual.
Do you have a legal definition of what comes under the heading traditional Chinese medicine? I mean, is it herbalists and acupuncturists? Or?
Well, everything is, herbal, acupuncture, and diagnosis. Those three things, and moxibustion, whatever that might be.
Well,
cupping, there's other procedures. Cupping is a traditional Chinese medicine. Good.
May I add, actually, if we look at the Traditional Chinese Medicine Act, we raised the concern long time ago during the 2005 2006 the debate in the Queen's Park. There's no clear definition whatsoever is what is acupuncture and what is traditional Chinese medicine. That is actually very odd. In a health regulation, these two most important things about what is your profession never been defined in the law, and also never been defined in this regulation of 2713.
Legislation to come into force? Like, do you have any specific orders you're seeking?
We just want the injunction, but we believe that when the injunction is granted, that the minister will want to listen to, because the minister has a supervisory power over this thing. I mean, it's not the minister, it's in the hands of the college. It's in the college, it's in the hands of the minister. And we think if there's an injunction granted, the minister will want to know why and how it can be remedied, that can be remedied. Our purpose is not to have a college. Our purpose is to have a college that listens, hears, and is reasonable and represents everybody.
So what's the best
When you talk about representing everybody, Dr. Lee has two particular experiences, one in which he was invited by the registrar, Miss Emily Chung, to come to a meeting, and when he got to the meeting, he was told that the meeting was full, but he snuck in and got in otherwise, and the meeting was half empty. A similar experience in same thing. What was the second one? I can't remember now.
That was the one we just mentioned that they use the police force to eject our member who just sitting there for 2 hours and have a question period and says no, you cannot answer anything.
So this is why we say we have got a biased college with credentials that are not 100%. And I tell you, if you take a look at the credentials of Cedric Chung, you'll find that apart from a university degree in BA in what I don't know, and an undeclared, just took learning in physiology, medicine and physiology, that his only doctor credential, it comes from the Taiwan Yuan. But when you write the Taiwan Yuan, that's the Board of Examinations, they find that we don't know Cedric Chung. So I went ahead and wrote the Shanghai University Medicine, where he's supposed to be an honorary professor. They don't know him there either. So we have real concerns about the reality of these people who are writing these regulations.
What's going to be the best outcome for the Federation? What's going to make you guys happy, that they are written in Cantonese or Mandarin?
Oh, sure. That's one of the things. But there are a variety. The herbal medicine, and there, as I say, there's some complicated structures built into the statute, which like, for example, we want a definition of English, what constitutes an English requirement. We want some biomedical ethical ideas that don't apply to traditional medicine struck out, and so on. I mean, there's a whole series of them. But the language, you're right, is about 80% of it.
So do you think the April 1st deadline will cause chaos within the TCM industry? And also that's why the injunction is applied?
Well, I don't think it'll cause chaos, no. Not really. Because there will be a hearing on the within 2 months. But after that, if we don't get an injunction, it'll be chaotic.
You know, because I know many petitioners, they try to register before the April 1st deadline, but even they don't really look at what's inside the constitutions.
Well, because there's a jurisprudence handbook, which is 160 pages, and deals with complicated sections of the Health Act and other things like that. It would be impossible for a person, even with reasonable English, to comprehend.
So the assurance.
I think they say, well, we write an exam and whatever it is, they pass it. I don't know what kind of exam. Miss Pritchard, for example, is she claims to be a PhD in the Open International University. Well, she got her PhD by writing a 300-page essay. That was her thesis, a 300-word essay. So anyway.
Sorry to interrupt. The insurance that you got from the councils this morning in court, was it in writing or just verbal?
No.
Okay.
I want to be very careful. They gave me no assurance. All they gave me was the fact that the council will be too busy and the members ought not to worry because nobody's going to get around to prosecuting. They're so busy. It's before the 30th of May. So they didn't give me a written assurance. There's nothing except discretion. But I say people should go ahead and continue practicing. If there's any problems, let me know.
So is it legal or illegal between April 1st and the end of May?
Well,
for the practitioners.
Yeah, if you want to look at it that way, people will be practicing contrary to a regulation that is suspect and could be struck down. So that's about the best you could say. That's the legal nature of it.